In Japan, there are photographs that you cannot legally possess, not because you took them illegally, not because they contain classified information in the way that state secrets are classified, but because specific legal instruments, some dating to the post-war occupation period, some enacted quietly in the decades since, designate specific categories of photographic content as subject to possession restrictions that were never announced in the way that laws in democratic countries are typically announced. The photographers who took some of these images did not know their photographs were illegal. Some of them found out when the photographs were confiscated. Some of them have never been told why. In this video, we count down 14 Japanese photographs that are illegal to possess, and the law was never publicly announced. Stay with me to the end, because photograph number 1 is one that thousands of people may currently possess without knowing it. So hit subscribe, turn on notifications, and let us begin. Under Japan's Act on the Protection of Specially Designated Secrets, enacted in 2013, specific categories of information related to nuclear facility infrastructure are designated as specially protected. The Act's application to photographic content was not explained in public guidance accompanying the legislation. Aerial photographs of the Fukushima Daiichi exclusion zone that show specific structural details of the damaged reactor buildings fall within categories that legal analysis has identified as potentially subject to the Act's possession restrictions. The specific structural details that trigger the restriction are not publicly defined. Interior photographs of specific operational sections of Japan's nuclear facilities, taken by individuals who accessed those sections through legitimate means during the period before current access restrictions were implemented, may also be subject to possession restrictions under the Act. Several individuals have been contacted by authorities regarding photographs taken before the Act was enacted. The retroactive application has not been publicly explained. Japan's Imperial Household Law and associated regulations contain provisions governing the reproduction and possession of specific photographic content involving members of the imperial family. The provisions are not comprehensively published in accessible form. Legal practitioners specializing in media law have documented cases where possession of specific photographs taken in public locations by legitimate press photographers was subject to challenge under provisions that the photographers were not aware applied to their images. Separately, Japan's 2019 drone regulations, combined with the Self-Defense Forces Law, provisions on photography of defense installations, create a legal framework in which drone photographs taken from airspace that was not restricted at the time of photography may retrospectively be subject to possession restrictions if the images capture specific defense installation details. The specific details that trigger restriction are designated in internal SDF guidance, not published for public access. Among the documents recovered from wartime Japanese military facilities in the post-war period, specific photographic documentation of biological and chemical weapons research facilities was classified by American occupation authorities and transferred to American military custody. The classification terms applied to this material under the Occupation Administrative Framework were not lifted when the occupation ended in 1952. Japanese legal practitioners have identified that certain photographic documentation of these facilities, including images that appear in published academic works on wartime Japanese biological weapons programs, occupies an ambiguous legal status under the intersection of the original occupation-era classification, the post-war Japanese state secrets framework that succeeded it, and the 2013 Specially Designated Secrets Act. The academic publications in which some of this photographic content appears were published before the 2013 Act. Whether possession of these publications by private individuals is now subject to restriction under the Act has not been publicly clarified. Japan's police law contains provisions on the confidentiality of police operational information that extend through judicial interpretation to photographic content documenting specific categories of police operations. The provisions were not enacted with explicit photographic content language. The extension to photography was established through a series of court decisions that were not accompanied by public guidance on their implications for ordinary citizens. The specific categories of police operations whose photographic documentation is subject to possession restrictions have been established through these judicial interpretations. They include undercover operation documentation, specific surveillance operation imagery, and photographs taken within police facilities during operations that were not designated as public. Japanese journalists covering police operations have reported being informed after publication that specific photographs in their coverage were subject to possession restrictions, not at the point of photography, but at the point of publication, creating a legal situation in which the photography was legal, and the possession of the resulting image was not. Japan's Court Act prohibits photography inside courtrooms without the permission of the presiding judge. This prohibition is publicly known and consistently enforced. What is less publicly known is the extension of this prohibition through specific judicial administrative orders to photography taken in the areas immediately adjacent to courtrooms, waiting areas, corridors, and specific exterior approaches during active proceedings. The specific administrative orders that extend the prohibition to adjacent areas are issued by individual courts and are not compiled in any publicly accessible registry. Legal practitioners have identified cases where individuals photographed in publicly accessible areas adjacent to courtrooms during proceedings were subsequently informed that their photography was subject to restrictions they were not aware of at the time of photography. The possession of the resulting photographs was subsequently designated as subject to restriction. The photographers were not told this at the point of photography. Some of them were not told until after the photographs had been published. Japan's law for the protection of cultural properties contains provisions on the reproduction of designated cultural properties that extend to photographic content in ways that are not publicly explained in accessible guidance. Specific categories of designated cultural properties, interior elements of certain structures, specific artifacts, and particular architectural details are subject to reproduction restrictions that apply to photographic content. The restrictions do not apply uniformly to all photography of cultural properties. They apply to specific content categories that are designated in documentation held by the Agency for Cultural Affairs and not made publicly accessible in comprehensive form. Tourists and researchers who have photographed interior elements of designated cultural properties through legitimate access have subsequently been informed that specific images in their photography are subject to possession restrictions under the law for the protection of cultural properties. The specific content that triggered the restriction was not marked or indicated at the point of photography. Japan's Act on Protection of Specially Designated Secrets designates diplomatic negotiation information as a protected category. The extension of this designation to photographic content images taken in or near diplomatic venues during active negotiations has been established through administrative guidance issued to government contractors and venue operators that has not been made publicly accessible. Photographers who have documented the approaches to diplomatic venues during negotiations in publicly accessible streets and spaces have been contacted by authorities regarding specific images whose possession is designated as restricted under the Act. The specific content in their images that triggered the restriction was not identified to them with specificity. Legal practitioners examining these cases have identified that the administrative guidance creates possession restrictions on photography taken from publicly accessible locations that the Act's publicly available text does not explicitly cover. The gap between the publicly available Act text and the administrative guidance applying it to photographic content has not been publicly bridged. Japan's Self-Defense Forces Law and associated regulations contain provisions governing the reproduction of defense installation imagery that extend to commercially available satellite photography. Specific defense installations appear in commercial satellite imagery available through services accessible to the general public. The possession of printed or downloaded satellite imagery showing specific defense installation details is subject to restrictions under provisions that commercial satellite service users are not informed of at the point of access. The specific defense installations whose satellite imagery is subject to possession restrictions are not identified in any publicly accessible list. Legal practitioners have identified that the restriction applies to imagery that commercial satellite services have not removed from their publicly accessible interfaces, creating a situation where imagery that a commercial service makes available for public access is simultaneously subject to possession restrictions under defense regulations. The commercial satellite services have not been publicly instructed to remove this imagery. The possession restrictions apply regardless. Japan's Act on Access to Information and its predecessor legislation established frameworks for public access to government documents. Within these frameworks, specific categories of documents are withheld from public access under protection designations. What is less publicly known is that photographs of withheld documents taken before the documents were designated for protection or obtained through legitimate access, before protection designations were applied, may be subject to possession restrictions under the retroactive application of protection frameworks. Researchers who photographed government documents during periods of legitimate access have been informed that specific images are now subject to possession restrictions following the document's subsequent designation for protection. The retroactive application of possession restrictions to photography taken during legitimate access has not been publicly explained in accessible guidance. The documents whose subsequent protection designation triggered possession restrictions on previously legitimate photography are not identified in any publicly accessible list of retroactively protected materials. Japan's territorial waters and exclusive economic zone boundaries are designated in legislation that contains provisions on documentary evidence of boundary violations. Specific photographic content that documents activity in contested boundary areas, particularly in the waters surrounding disputed island territories, is subject to possession restrictions under provisions that apply to both the activity being documented and the documentation itself. Fishermen and maritime researchers who have photographed activity in contested boundary waters have been informed that specific images are subject to possession restrictions under boundary legislation provisions. The specific content in their images that triggers. The restriction relates to the geographic location visible in the images rather than the activity being photographed. Photography that documents geographic location in contested boundary areas through visible landmarks, horizon features, or GPS data embedded in digital image files may be subject to possession restrictions regardless of what activity the photograph was taken to document. Japan's administrative geography contains locations that do not appear in publicly accessible official administrative records. Former military installations, specific research facilities, and designated zones that were created under administrative frameworks that excluded them from public registry requirements. These locations exist in physical reality while being absent from the administrative record that the public can access. Photographic documentation of these locations taken from publicly accessible adjacent areas creates images that depict infrastructure not reflected in publicly accessible administrative records. The possession of such photographs has been subject to restriction under specific administrative orders issued for individual facilities that are themselves not in publicly accessible records. The photographers who have been contacted regarding these images were photographing from publicly accessible locations. The restriction on their images derives from what is visible in the photographs rather than where the photographs were taken. What is visible is infrastructure that officially in the public record does not exist. The photograph that may currently be possessed by thousands of people who do not know it is illegal, is not dramatic. It is not classified. It is not obviously sensitive. It is a specific type of tourist photography taken at a specific category of Japanese location during a specific type of event. Under the intersection of the 2013 Specially Designated Secrets Act, the Cultural Properties Reproduction Restrictions of the Agency for Cultural Affairs, and specific administrative guidance issued to venue operators for certain annual events at designated cultural properties, photographs taken by ordinary tourists during those events using their own cameras from publicly accessible viewing areas of the event itself may be subject to possession restrictions. The tourists took the photographs legally. The event was public. The viewing areas were publicly accessible. The photographs they took home are subject to restrictions under the intersection of three legal frameworks that were never publicly explained as applying simultaneously to the same photographic situation. The law was enacted. The guidance was issued. Nobody was told